Hello, everyone, and welcome again to this week's edition of Smart Counsel for Lunch. I am Brittany Hinojosa Citron. I'm an attorney here at Samuel, Sayward, and Baylor in Dedham, Massachusetts. We concentrate our practice in estate planning, elder law, probate, estate and trust administration. And today I will talk about the differences between a healthcare proxy and a living will. Each state has their own laws and best practices, so I will talk about these documents specifically to Massachusetts. A healthcare proxy and a living will are both important healthcare documents that one should have in the event that you are unable to make your own healthcare decisions for yourself, whether you're unconscious during surgery, in a coma, or in an end-of-life situation. The purpose of the healthcare proxy is to name someone, a proxy, to make healthcare decisions for you on your behalf. It's only effective when your doctor certifies that you are incapacitated and unable to make decisions, and it covers almost all healthcare decisions, including treatment, procedures, and medications. Your healthcare proxy will also make decisions about end-of-life care and life-sustaining treatments, like resuscitation, ventilation, and tube feeding. And this is where your living will comes in. A living will is a separate document from the healthcare proxy that states your preferences about end-of-life care and life-sustaining treatments should you become terminally ill or permanently unconscious. The healthcare proxy is more broad about medical treatment, while the living will is limited in focus as to end-of-life care. The living will doesn't name your proxy, but rather provides a guide for your proxy to inform doctors and family members about your wishes. That's the biggest difference. Another difference is that Massachusetts doesn't have a statute specifically recognizing living wills as legal binding documents, while the healthcare proxy is explicitly recognized and regulated under Massachusetts law. Your living will can still be used to express your wishes, and it's considered by doctors and courts as a reflection of your preferences, but it's technically not legally binding and not backed up by Massachusetts law statute. And speaking of preferences, the healthcare proxy typically doesn't include or specify your wishes about end-of-life care and life-sustaining treatment, unlike the living will. It simply names your proxies and specifies the authority that you're giving them to make healthcare decisions on your behalf. Your proxy can include your preferences about end-of-life care, and you certainly can do that, but it just might be better to have your preferences specified on a separate document like a living will, and that's because there's so many constant advances in medical science and available treatment. And if you wanted to update your preferences instead of updating your healthcare proxy every time and making sure your doctors and your loved ones have your most recent document, you can just update your living will with those preferences and not have to update your healthcare proxy all the time. So I hope this video was helpful for you in knowing the differences between the healthcare proxy and the living will. If you would like to create a healthcare proxy or a living will, or if you want to update an old one, you can reach out to us at our website, ssbllc.com. There at our website, you can also read other topics relating to estate planning, and if you can certainly watch more videos here on our YouTube channel. Thank you again for watching, and we'll see you next time.